Good morning, everyone. Can we have some more energy? Good morning. Thank you. How does it work?
Basically, forward, backward.
Forward and backward. Okay. Right. So first of all, I would like to thank the organizers for organizing this wonderful event where we spent some interesting time the last 3 days. Well, I have had a good time the last 3 days. And as we're heading towards hopefully better days after the COVID pandemic, let's hope we build a better tomorrow through whatever discussions we've had in this conference. I'll give you a bit of my introduction. I am Mushroofa Hosain. I am an advocate of the Supreme Court of Bangladesh, as well as an accredited commercial mediator under UK ADR ODR International, and I'm also the Director of Client Development of my chambers, Accord Chambers, which is one of the top-tier law firms in Bangladesh. And at the same time, I'm also the Managing Director of our company, which is called State Express Bangladesh Limited, which is one of its kind, the first of its kind, only M&A advisory firm in Bangladesh, as well as we do industrial real estate procurement for foreign direct investors as well as local corporates. We do joint venture collaborations between local corporates as well as local companies and foreign partners. And at the same time, we are also into trading of raw materials for the cement industry, and particularly fly ash. So that's quite a bit of a hat. And apart from all of this, I'm also an English television news presenter in the National Television of Bangladesh. Along with that, I have been a television anchor, hosting some legal talk shows in some of the private channels in Bangladesh. So, going towards my discussion. So the topic that has been given to me is how a collaborative legal team can streamline dispute resolution for complex mega projects. Does that sound very boring? Okay, so in the morning while I was coming here, I decided that let me not bore you with a typical lawyer-like discussion. Okay, let's be more interactive. So before I get into my discussion, I'll just give you a little bit of background about my country. I come from Bangladesh, which is one of the most remarkable success stories in terms of economic development, in terms of generating investment from foreign partners in the last decade under the leadership of our dynamic Prime Minister, Sheikh Hasina. Well, if I just give you a bit of a streamline, so Bangladesh, it's actually currently known as the next emerging Asian tiger because we are expected to be the 24th largest economy coming up in 2033. We have an annual 8% of growth rate, where we had actually surpassed our neighboring country, India, in terms of our per capita income. And along with that, you'll see that this is one of the, Bangladesh currently holds an investment climate which is very much flexible and very much encouraging for foreign investors. One of the reports of World Bank has stated that Bangladesh is one of the most liberal in terms of attracting foreign investors. So you might be thinking that why am I going to Bangladesh? I have to give you a background of my country because otherwise I can't get to complex mega projects, right? So since we are a very investment-friendly country, we have foreigners can actually own 100% have 100% ownership of companies in our country. We give the support of 100% foreign equity allowed. You can own your own company there. You can take in profits out as many times as possible, as many times as you want. And at the same time, you can actually take out your investment anytime you want. So you don't need a local partner. You can have 100% ownership of your investment in Bangladesh. So the investment climate is very friendly, and therefore we encourage foreigners to come in more. And at the same time, we are actually developing economic zones specified for different countries. We have a Chinese economic zone. We're developing an Indian economic zone. There's one for the Japanese. And we also hold a lot of Norwegian, Egyptian, Netherlands-based investments coming to our country. So as a result of which, we are having a lot of complex mega projects going on. And infrastructure development is going on over the past decade. And owing to that, the 8% growth rate that I've mentioned is actually as a result of the manufacturing industry, and the construction industry has actually contributed very, very, very significantly towards the development of this growth. So going forward, and some of the benefits that you can see that we have not only 100% foreign equity allowed, we have an amazing workforce, which many of you might know that, we have a lot of Bangladeshis working in different parts of the world. As we have competitive workforce, we have amazing tax incentives for foreign investors, and at the same time, we give the best support as much as possible with less complication in regulatory framework and permission from necessary authorities. Right. So as the world integrates towards advancement of globalization, how much do you think it is actually practicable, reasonable, and cost-effective to take disputes to courts? Any thoughts on that? In today's world, where we are having so many mega projects going on, with a combination with the participation of different countries based in one location, how do you think, in case of disputes, it is effective to go to the courts? Let me just break it away. So let's say a mega project is going on in Bangladesh, and you have Chinese stakeholders, you have Indian stakeholders, you have, let's say, Norwegian stakeholders. And then 3 of these countries participate in the mega project, and with multiple kinds of interest, there could be conflicting interest as well. And at the same time, so when the mega project is going on, how much do you think it is sustainable if for any particular dispute you have to run to the court? Courts are not the best place, at least in our parts of the world, because of the time that it consumes. Do you agree? Right. So we need to actually go towards alternative dispute resolutions, right? Do I make sense? So an alternative, when we talk about an alternative dispute resolution, what comes into our mind is maybe arbitration, mediation, or any sort of negotiation that helps to settle rather than going to the court, right? So how about taking measures from beforehand that you don't really have to go to court at all, right? Would that make more sense for at least our part of the world? That includes Bangladesh, India, and many South Asian countries. Do you agree? Right. So in order to do so, what we think is how a collaborative legal team can play a huge role in terms of defining the whole strategic measure, so that one does not need to go take refuge in the court when there's a dispute. Because in complex mega projects, you have a lot of risks exposed. How? When you have participation of multiple parties, there are a lot of costs involved. There are a lot of interests involved, where the interests could be of conflicting nature, where there could be parties coming with competing interest, and how do you protect that? In order to protect that, you need to have your lawyers aligned up in such a manner that they don't work as lawyers, but rather they work for you to protect your interest. Now, in today's world, legal practice is something, it's not of the traditional kind. As commercial practitioners, what we do is we prefer more out-of-court settlements. How? We look at the interest of the client, because that is how you can actually avoid any sort of risk exposure to your finances. How does that happen? So when you have multiple countries or multiple parties participating in complex mega projects, your lawyers need to align up together to identify your interests and protect your interests, have proper discussions to understand that how you align your contracts so that you do not fall into any sort of trap. Because in our part of the world, sometimes the drafting of contracts can be difficult. How it can be difficult? I'll take you back to some of the government projects that we're holding. In Bangladesh, we are having the Matarbari Deep Sea Port project going on, which is also being built by foreigners. We have the metro railway, and we also have the Dhaka Elevated Expressway that is being built by a Thai company. So, and all of these are being regulated by the government authorities, who are usually very rigid when it comes to contract making. Why? Because they follow a traditional method and they can't really go without that traditional method. But what happens is, when you follow the traditional way of making contracts, it cannot suit the best interest of the stakeholders. How does that happen? Because, let's say in a contract, it says, when there are multiple parties involved from multiple countries, you have one bit of a clause left there that in case of any legal dispute, one has to resort to the court of Bangladesh. How does that help? So you have an Indian party, interest of an Indian party, you have an interest of a Chinese party, you have an interest of a Thai company, but the contract says for any sort of legal dispute, you only have to come to the court of Bangladesh. Does it protect the interest of the foreign countries? No, right? So in that case, what you need to do is you need to have all of your lawyers working together in collaboration and devise the contract in such a manner that you can maybe hold an arbitration in a third country, in a third neutral country. So what we do is, in our case, we usually propose a third neutral country like Singapore. The reason for saying all of this is because if you do not align these components, if you do not align these components together from the beginning, what happens is, if you fall into a trap, if you fall into any sort of dispute, you just have no other, you're stuck. You just have to resort to a court solution, and that is not very effective. That puts a pressure on your finances, that puts a pressure on the delay of, that puts a pressure on the timeline of the project, and whatnot. So, streamlining dispute resolution for safeguarding investments and interests is very much critical for mega projects. Going forward, so the importance of streamlining this dispute resolution is how the lawyers can deal constructively. So the lawyers basically have to get together, understand the interest of every party, and construct the line of your contracts in such a manner that even if you fall into trouble, there is a scope of negotiation, there's a scope of doing out-of-court settlement, that it can actually create a much effective, it can come up with a much effective solution rather than causing time delay and bleeding your resources. So that saves resources, and it could avoid financial exposures. It can protect the reputation, because sometimes when there's a litigation going on in court, whether you are a party to that, whether you're the victim or whether you're the villain, it doesn't matter. The fact that you have some litigation pending in the court, it creates a very negative impression on the goodwill of the company. Do you agree? Right. So in case of mega projects, in order to achieve the ultimate objective, it is very important that your lawyers work together very closely. They come up with solutions, they come up with effective solutions, not through a legal mind, but of course aligning the business and the legal measures together so that you can come to a proper solution that at the end of the day, your outcome is assured. Because in today's world, business is moving really fast, and we cannot cause delays, we cannot keep bleeding our resources. We need to move ahead in such a manner that projects get executed faster. Right? So going forward, so when now what we can look into is what are the reasons for having disputes in mega projects. The project complexity, like I mentioned, that multiple companies can have multiple conflicting interest, so one needs to sit together and come to a realistic solution. And then there are some of these issues that actually creates, that contribute to disputes in mega projects. But all of these factors can be avoided just through a collaborative discussion between lawyers who don't work as lawyers, but who also bring in the business components together, who work with regulators together, and who work as a team to share each of their knowledge and come to an effective solution. Because in today's world, we as lawyers don't only have to have knowledge of the laws, we also need to understand what is the taxation method. We also need to understand what are the regulatory bodies thinking of. We also need to understand that how does the business actually work. Because sometimes contract is just a piece of paper, but in reality, when you do the business, you understand that, it's not what's only written on the paper. The way it functions practically is something totally different, right? So, do I make sense so far? Yes? Okay. Now, yes, some of the reasons, one of the major factor that actually causes hindrance to mega projects is political constraints, which, by the grace of Almighty and by the dynamic leadership of our Prime Minister, of our Honorable Prime Minister, we have avoided that for the last decade. So, the magic of collaboration is very important, and where people can combine their perspective and expertise and tailor them to meet their clients. And I'll tell you, in this manner, one can actually, it's rather more effective and much more rewarding even for the lawyers. Because, from a lawyer's perspective, you can actually have more billable hours. So it's also very economical for the lawyer. You earn more. And it also saves the particular company involved, the client involved, from bleeding resources in the future. So maybe at one time he has to pay a little bit more, but then again he's saved for the future. So it's actually economically viable for all parties. So, and it is also it would actually turn out to be a very good hub for sharing knowledge in multiple areas. So, and that means that specialists have to combine together to deliver a project rather than experts working separately in disciplinary slots. Now, why do I get here? Sometimes, as lawyers, we become quite reluctant to actually work with a team because, we get very protective about our client. But in today's world, we need to come out of this practice because it is much more healthy for a better tomorrow, and for business to go on, we need to work as a team. Right. So what are the benefits of a collaborative legal team? It can help you waste your time. It can reduce wasting time. It can assure plenty of learning opportunities for lawyers, regulatory bodies, and all kinds of people involved who are working together. And here we are learning different modalities of work as well. When all kinds of mind combine together, we learn to share ideas from different sectors of areas that needs involvement in any particular work. So, I'll just skip that. This is a research from Harvard Law School, which also says that when firms can get their partners to collaborate across practices, offices, and jurisdictions or other internal boundaries, the financial gains to the firm are unambiguous. So one of the clearest measures of this finding is the link between cross-practice collaboration and revenues. Simply put, the more practices that are involved in servicing a client, the greater the annual average revenue that client generates. So at the end of the day, it's actually benefiting the client in a manner that you earn more revenue and you have to spend less on legal costs. Going forward, so, right. So going back, a collaborative legal team cannot necessarily, well, one cannot assure that a collaborative legal team can actually ensure that you do not have to go for disputes at all. No, they cannot do that. But at best, what we can do is we can actually minimize the risks of going for a legal disaster. So the lawyers can work together to minimize the risk of having greater disputes which take you forward towards litigation. So because sometimes each of these mega projects, not exactly sometimes, because mega projects are of different size, of different nature, and of different complexities. So it's all one of its kind. So one of its kind, meaning that, you know, not every one of them fit into the same hat. So the kind of legal measures or the kind of measures that you have to take for one project is not necessarily the same that you have to take for another project. But sometimes in our part of the world, what happens is the authorities who are responsible for taking care of such projects, they feel that they want to take precedence from other decisions and they want to implement it into every project. And it doesn't work out that way. Do I make sense? And this is where a legal collaborative team can actually play a major role in terms of defining the differences between how unique each of the complex mega projects are. Now, through an enhanced discussion, what can a collaborative legal team achieve? Like I said, that it can achieve a balanced and clear risk allocation. It can actually advise the parties from the beginning on what should be the nature of the contract to suit their interests to the best, and ensure alignment of the parties' needs and interests in contracts, of course, and each of the interests of every party is different in nature. And like I said, that understanding the legal, regulatory, tax framework and effect of the necessary authorities concerning that particular jurisdiction where any particular mega project is going on, or any particular set of industry, is very important to understand. And one can take measures in such a manner that you don't necessarily have to go for even an alternative dispute resolution. Meaning that, you know, you can protect it can help you to protect your interest in such a manner that you do not have to take any measures to even go forward to that part that, you know, you need to have, that you get into a dispute, and even if you require the dispute to be solved even out of court. You don't need to go to that stage. It can avoid that part as well. So this is more about it, and mourning is just not my thing, to be very honest. I don't know if I could actually convey the message in the right manner, but of course, the floor is yours now. Any questions, I'm happy to take. Yes, please.
That was a great talk. I appreciate that.
I did make sense?
Well, I'll answer that after my question.
Right. You know, sometimes as lawyers, I'll tell you, it is actually quite difficult for us to think from the perspective of a regular person. When we talk, we tend to think, oh my God, we're just talking like lawyers and nobody would understand what kind of message we're trying to give. Anyways, so I tried my best.
I want to go back to a point that you mentioned, that the court of Bangladesh cannot take the interests of the countries that are participating in the project.
I'm not clearly, I'm not being able to hear you clearly. I'll come forward, yeah.
I know, there's a lot of echo. So you said the court of Bangladesh operates in the interest of the country and not in the interest of the countries that are participating in the project, right? And my question is, why wouldn't that be the right thing to do? Because the project benefits the Bangladeshi people, right? So any conflict resolution has to be in the interest of the people, not in the interest of India or China or Netherlands or whoever is operating there. So, but I felt like you thought that was not the appropriate thing.
Well, that's a very good question. You're right that, you know, yes, we are benefiting from mega projects, and that should always be for the interest of the parties, and we must take care of it. Yes, you're absolutely correct. But I think, you know, since the kind of change that we are going through, our courts are still not prepared to have a very liberal approach. So when we represent some foreign clients working in our country doing EPC projects or doing power plant projects or any mega infrastructural project, we see that sometimes the regulatory bodies do not have, first of all, our courts are still not ready yet to take that liberal approach to understand that, when a foreigner is coming to do business in my country, I need to be extremely liberal. Well, but then again, I should not say it like that, because we have come up with decisions out of court which came in favor of the foreign client who was working in Bangladesh. So, but I think our court structure, this is the reason why we actually advise clients not to go to courts in our country, because it is best for the commercial interest to settle it outside court, and we did come up with some good outcomes. But like I said, that yes, our courts still need more time to take that liberal approach, but we're gradually moving towards that. And sorry, you had another second part to your question. So did I answer you correctly? Okay, you got you. Thank you.
Yeah.
Yes.
First, let me congratulate you, multi-talented, lawyer, TV anchor, newsreader, then businesswoman. Congratulations
Thank you.
to you.
That's very kind of you.
Yeah. First, any contract, to best of my this thing, contracts are defined by the client, like government contracts. They'll have so many conditions, predefined conditions. If you accept those conditions only, we are going to bid for the contract. So you are talking about so many things, so you have to take care of this and all. So do I get as a contractor, do I get an opportunity to dispute before, or raise a objection before entering into contract? Normally it is not possible. Unless you accept only, they will allow you to participate in the bid.
Right. So for tender documents especially,
Yeah, exactly.
yes, for tender documents, sometimes there are options, because you see, when foreign investors come and participate into tender, projects that are based on tender in our country, you usually take hold of local partner, right? And sometimes, yes, before the tender documents come out, you might have some scope to change it and make it friendly, make it suit to the nature of a foreign client. There could be a scope on that, but that depends on what sector of industry it is. In some areas, it may not be possible. But then again, actually, initially, the approach is very liberal, because we want to attract foreign investors. Foreign investors come in, and we want them to participate. But what actually goes wrong is, when these complex mega projects get done, there are stages. At different stages, you need to submit different paperwork, right? Different types of documentation. You have to have multiple contracts at multiple stages. So let's say the first two phases were very user-friendly. And at the third stage of the contract, it turns out to be that, there's one particular clause which is turning out to be very difficult for a foreign investor. Or maybe even if it's liberal, a slight bit of dispute arises, and then the concerned person in the regulatory body, or the concerned person who's being set as the director of that particular project, may not sometimes have the required skill to understand that, how these things operate. Because sometimes you have people, let's say, coming from an engineering background, taking care of a healthcare project, for example. So in order to understand how a healthcare project works, you probably need somebody with that kind of a background to understand that how it needs to be operated, or vice versa. Like, I'll give you an example that from one of my personal experiences. Before the COVID-19 pandemic, one of our foreign clients had participated in a project and had submitted a quotation for the completion of the project. What has happened later was, after the pandemic, due to the pandemic, there was a delay in receiving the work order, and that particular client could not start the work. And eventually, after the pandemic, when he was given the work order, he mentioned that, now I need to raise my cost price. So when he actually approached the government body to raise the contract price, it came to a dispute. Why? Because the government body was no longer willing to increase the price. But, you have to take a caution of the practicalities. The global pandemic has affected everyone globally. Freight costs have gone up. All other material costs have gone up. Construction material costs have gone up. So the quotation that he has given pre-pandemic and post-pandemic has to be different. And, post-pandemic, it is not possible to match with the price of pre-pandemic situation. So, sometimes these sort of disputes arise, but which we eventually settled outside court. We conducted an arbitration, and then the outcome came out to be favorable to the foreign client. So that's how it gets.
Will government allow to go out of court settlements? Normally they don't entertain, no? They wanted to go to the court only. Government.
No, Bangladesh has actually signed the New York Treaty, so we are a part of that unilateral law model. So in every contract there has to be an arbitration.
Yeah,
So,
arbitration clause.
right. So there has to be the first option that needs to be exercised is out of court settlement. So we are still getting there, but still arbitration and out of court settlement is a very common approach nowadays.
But in general, my experience, when the arbitration award goes against the government, they'll again go to the court and they'll go for appeal.
Not in our country. Not in our country. If there's an arbitration going on and the outcome is, it's not about being favorable to whichever party, but if the outcome, if both parties are agreeing, going for an arbitration, that arbitration award can be.
If it is a mutual consent, they will not go. But one
No,
person,
even our I have to give some credits to the courts of our country in this regard, because when there is an arbitration that has taken place and an arbitration award has been given, when that person usually approaches the court actually asks them to implement the arbitrary awards. So the courts has taken a liberal approach in that case, especially in terms of commercial contracts. So they say that, it's a commercial matter. It has already been settled outside, because the people who are conducting arbitration are also legal practitioners. They have vast experience. So when they come up with an arbitral award, usually the courts don't dispute that. They say that, you have to follow whatever the arbitral award is. So there has been some liberal approaches taken in that manner.
But justice cannot be done every time, no? Arbitrator also can give suppose against the contractor, if he gives some award,
well, it was.
then he will be the loser again.
Yes,
not an
I
opportunity to go
agree
for
that sometimes it can give a negative outcome. Of course, it can give a negative outcome, and if you can prove it in that manner that it is a biased outcome, you can definitely resort to the courts. But in this part, our courts have played a very liberal approach, which comes out to be quite favorable for foreign investors. Any further question? Okay, thank you all once again. And thank you for the organizers for feeling me worth coming to speak on this stage. Thank you.